Hello, and thank you for joining us. We're excited to have an awesome group of Miamians watching tonight, including faculty, staff, students, and friends, as well as alums and students ranging from classes of 1958 to 2022. We hope you'll be involved. You can ask questions or leave comments using the Ask the Question link below the video. I'm excited to be joined by Ashley Adams. Ashley Adams is an EJI staff attorney. She earned a BA from Vanderbilt University in 2008 and graduated from the University of Tennessee College of Law in 2011. Prior to joining the Equal Justice Initiative in 2017, she was the Assistant Public Defender and District Court Supervisor for the Tuscaloosa County Office of Public Defenders, represented Indigenous clients as a trial attorney with Jefferson County Public Defender's Community Law Office in Birmingham, Alabama, and conducted civil litigation as an associate attorney at Gaines, Galt, Hendrick in Birmingham. Welcome, Ashley.
Hey, Valerie, I'm Dr. Carmichaels. I'm sorry. Glad to be here and to talk with you all about the Equal Justice Initiative and the work that we do. And what we hope for our country, especially in this time that is anxiety producing and a very nervous, nerve-wracking time for everyone. So I'm going to begin by giving a little bit of background on myself, a little bit more. I did start out my career in 2011 as a public defender in Tuscaloosa County. I wanted to be a public defender when I graduated from law school. I'd done a lot of public interest work while I was in law school, and I was able to go to the public defender office in Tuscaloosa County through a program that was called the Public Defender Corps, which I kind of describe as being like Teach for America, but for public defenders. A lot of public defender offices struggle with hiring new public defenders because of budget crunches. So this program was funded by the federal government. It had some help from the federal government. So I was able to be placed in this position in Tuscaloosa County and help their office with their cases. I then moved to the Birmingham office in Jefferson County. It was a newer office, so I wanted to kind of get the experience of what it was like to work in an office that was not as established as the Tuscaloosa office. So I've gotten the experience of being in a very old public defender office and a very new public defender office. And then I got a little bit burned out on public defender work, which is normal. It happens a lot. I stayed a little bit longer than the usual average burnout person, but I did civil litigation for just a little while, about 10 months before I realized like this is not my calling and I want to return back to criminal defense. And that's how I ended up at EJI. So I love the work that we do. It allows me to do criminal defense work, but it also allows me to do it at a slower pace, but also to talk about race and economic injustice. So the Equal Justice Initiative, which is the organization that I work for, was founded in 1989 in response to a crisis that was going on in Alabama in the criminal legal system. At the time, Alabama accounted for 25% of the executions going on in the country at that time. And Brian Stevenson, who is our executive director and founder, was working in Atlanta at the Southern Center for Human Rights, which is a great organization out of Atlanta. And he received a call from Eva Ansley, who is a co-founder of the Equal Justice Initiative. And she alerted Brian that we need someone here to help the people who are on Alabama's death row, because we are accounting for a significant portion of the executions going on in this country. And the reasons for that are reasons that are just a violation of human and civil rights. I should also give a small warning that I have 2 dogs in the next room. So you may hear some occasional barks, but as for back to our founding, we accounted for 25% of the executions at the time. And the reasons for that were many. what shapes Alabama, the criminal legal system here, are three big factors, and that's politics, poverty, and race. So as for politics, our judges here are elected. So they run for their seats as any other politician would. They put out ads. They use the same slogans a lot of times. So a lot of times their goal is to tough on crime their way into a seat. So we have, in the late 80s, you had judges who were running for office who were very outright and very blatant about what they hoped to do as trial judges or as appellate judges. So they would say things, you know, like, I'm going to be tough on crime, or they would use their opponent's lack of using the death penalty as a opposition point. So they would say, I'm going to use the death penalty. I'm going to sentence people to the death penalty when I'm in this judge seat, versus my opponent who only used the death penalty once or has never used the death penalty. So using the death penalty has become a way to gain constituents and get people to vote for you. So there was the political aspect. Judges were also able to utilize a scheme called judicial override. Judicial override was abolished in 2017, but up until 2017, it allowed judges to essentially override a jury's recommendation of life without parole. So if you were convicted of capital murder and then you were sentenced, a jury could say, we recommend that this person be sentenced to essentially die in prison, which is what a life without parole sentence is. The judge could then say, I disagree with that, and I am going to sentence this person to death. What we saw was that in the time that judicial override was in practice, most of the time, if not all of the time that it was used, it was always used to override a jury's recommendation of life without parole to a sentence of death. It was never used in the reverse. So there was not an instance where the jury recommended death and a judge overrode it to life without parole. I think if there was, it was maybe one time, if I'm remembering correctly. But it was almost always used to override a sentence to death. What we also noticed was that it was always used when a death sentence involved a Black defendant. And that would be a Black defendant who's been convicted of capital murder and their victim is white. So the judge was more likely to override to a death sentence if you were a Black defendant and your victim was a white person, versus if you were a white defendant and your victim was white or your victim was Black. And that's the political aspect of it. Politics comes into play in several other ways. Here in Alabama, we don't have any African-American judges in the appellate seats. We don't have, in the history of our appellate courts, we have only had 2 African-American judges. But currently, all of our appellate judges are white people. We only have 2 African-American elected district attorneys. They are in the same county that is split into 2 divisions. So Jefferson County, where Birmingham, Alabama is the Jefferson County legal system is split into the Birmingham division, which covers just about, like a large portion of the county, but not all of it. And then the Bessemer division, which covers a small portion on the western side of the county. So in all of the other counties, the district attorneys are white people, and mostly white men. And that, of course, leads to disparities in how our criminal justice system here plays out. When most of the people in the court are white people, the judges are most likely white. The district attorney is going to be who's, deciding who gets charged with what is white. And when the case is done and is appealed, that person reviewing the case on appeal is going to be a white person. So that's the political aspect of our criminal legal system, and definitely so at the time that Brian came over to found the Equal Justice Initiative. Poverty is also a big factor in why our criminal legal system is the way it is, and especially why it was the way it was in 1989. Alabama still does not have a statewide public defender system. We're the only state that does not have one. So what that means is if you are accused of a crime and you're poor and you can't afford to hire an attorney in Tuscaloosa County, you will be provided an attorney from the public defender's office. However, if you are poor and accused of a crime in Wilcox County, Alabama, you will be appointed a attorney from the private bar. What that means here is that the level of representation, the adequacy of your representation may very well differ because public defenders are in an office where everyone practices criminal defense versus a private bar attorney who more than likely does not get their bread and butter from practicing criminal defense. They more than likely practice civil litigation and other types of law that are not criminal defense cases. So that could lead to you receiving a level of representation from someone who is not very knowledgeable in how the criminal legal system works here, and can change the outcome of your case because you have not received adequate representation. Another aspect of that is that everybody on death row is poor. If you are not poor when you are first accused, you will more than likely be poor by the time you get placed on death row because it requires a lot of money. If you are able to pay for your trial and your experts and pay your attorney, you will most likely not have any money left by the time you do get to death row. So it is pretty much safe to say that no one on death row is rich. There are no rich people on death row. You are also not provided an attorney after the direct appellate process. Here in Alabama, your appeals after you are convicted of capital murder happens in 3 stages. You have your direct appellate process, your post-state post-conviction process, which is the first opportunity that you have to claim actual innocence. And then you have your third set of appeals, which is the federal level, going before a federal court and asking them to look at your case if you were not successful in the direct appellate stage or the state post-conviction stage. In Alabama, you do not have the right to an attorney once you hit the state post-conviction stage. So you have a large number of people here in Alabama on death row who are at the state post-conviction stage, and especially in the late 80s when we were founded, who don't have an attorney because they're not entitled to one. You're only entitled an attorney up through your direct appeal process. So the post-conviction stage is just as important as the other stages, especially since it is the stage where you can first assert that you are actually innocent. And proving that you're actually innocent takes a lot of resources. It takes, you have to hire experts. You may have to go back out and interview jurors. That requires traveling all over the state and staying in hotels possibly so that you can catch up with people and talk to them, and hiring experts who, charge hefty fees to look at your case. And people who are on death row don't have that kind of money, and they don't have the money to hire an attorney and pay them for the resource intensive work that it would take to carry a person through their state post-conviction phase. So it is, once you get to that stage, it is very, very hard to keep your case going when you are not able to afford an attorney. Another aspect that shapes the criminal legal system here, and especially so in the late 80s when this office started, is race. Race plays a big factor. We, in McCleskey v. Kemp, which is a United States Supreme Court case that came down in the late 80s, the studies and the data in that case showed that if you were a Black defendant, you were more likely to be sentenced to death if if your victim was white. So there's data that shows that racism is a part of our criminal legal system. And through our work, we have seen that race and economic injustice or poverty are the two big factors that shape a lot of people's trajectory when they are accused of a crime, and especially capital murder. We also noted that here in Alabama, it was and still is a big problem with all white juries trying Black defendants. So it is still very possible for you to be a Black defendant today in Alabama and end up with an all-white jury. This is a state that has a population of Black people at 26%. And some of the counties themselves where trials are held have 26% or more, sometimes predominantly Black populations in them, and you still may end up with an all-white jury. And we believe that that is a demonstration of something going wrong at the trial stage. So we have been successful through our existence in being able to get those kinds of cases, which are essentially Batson violations, Batson v. Kentucky violations. It is unlawful for the state to discriminate in jury selection, to strike all Black people from a jury simply because they are Black, which happens a lot. We have been successful in our existence in getting about 30 of those cases overturned on Batson violations. It has been a lot slower in recent years, but that is something that we were very successful with in our early years. So in our early years, we primarily represented people in that last stage of appeals, which was the federal stage. And we were able to, over the course of our existence as an organization, we've assisted about 130, 140 people with coming off of death row and getting their sentence commuted or helping them become exonerated, which is to be completely, shown as being innocent or not guilty. And in total, since the death penalty was revived in the late 70s, there have been 160 people. There have been about 1,600 executions since the late 70s, and 160 people who have been completely exonerated, which means that they have been shown to be innocent of the crime that they were accused of. So that's a startling number there. That's about 10% of people who have been out of the 10% of the executions that have gone, and 10% of the out of the 1,600, there have been people who have been completely exonerated. And that's startling because there may be people, there are more than likely people who have been executed, who are actually innocent, and who are awaiting execution that are actually innocent. And we believe that that's startling, and that that is one of the reasons that the death penalty should be abolished, is because of that error rate that 160 exoneration shows out of the 1,600. So we were successful in our first few years as a organization, and then in the mid-90s, some changes started to happen on the federal level, and that, of course, kind of seeps down into the state level laws. Our funding was stripped. We didn't receive any more federal funding to do the federal cases that we were working on. And a lot of organizations had that happen to them. Brian was able to keep us afloat and turn us into a private nonprofit organization, which is what we are today, which means that we do not receive any federal or state funding. We don't receive any government funding, and we subsist on individual donations and donations from large foundations and their grants. And that has allowed us to kind of branch out into some other project areas that we thought were very important and presented crises within themselves because of what we had observed with our death penalty work. Since the late 1970s, the prison population here in the United States has exploded. During the 1970s, the prison population was around 300,000 to 500,000. Today, the United States incarcerates the most people in the largest proportion of people in the world. It's one of the top incarcerators. We incarcerate 5% of the world's population and 20% of our own population, which is just not only embarrassing, it's just startling and atrocious. And we incarcerate 2.2 million people. So from the 1970s to today, our prison population has gone from the hundreds of thousands to 2.2 million people. When you add in the number of people who are on probation or parole, that number jumps up to about 4 million people. So there are 4 million people who are either incarcerated or under some type of court or post-release supervision. And that is, and you can imagine some states make it to where you can't vote if you have a felony conviction. So there are a lot of people, millions of people who are disenfranchised as a result of having a prior felony conviction. So it has meant a lot of changes in our the status of people who are released, the status of people who are incarcerated. And that also doesn't bode well for when people are looking for jobs. It doesn't bode well for when people are looking for housing. It has shaped our society in a negative way and disenfranchised people in various ways that are not good. And the result of that, you can see that demonstrated in Florida, where people there who have prior felony convictions are fighting really hard to be able to vote. And every time they gain a victory, the courts or some politician does something that kind of sets them back. But that's, if you've been keeping tabs on that, that's a demonstration of how mass incarceration has negatively affected our society. But noticing these stats, we wanted to begin to combat the some other consequences of mass incarceration. One of those is overcrowding. Alabama is a state that I believe the last time I checked, it was our prisons and jails are built to hold like 7,000 people, but we're operating at a number of like double that. So overcrowding leads to the wearing down of buildings. A lot of our buildings are really old. They were built in the 1960s. They haven't been kept up. More people have been placed in them than they were meant to hold. Remember what I said about the population being in the hundreds of thousands in the 1970s. Those prisons that were built in the 1960s, I don't think the people who built them or the people who planned them foresaw double that amount holding, being held in those facilities. As a result, you have people piled on top of one another that is aggravating, that can be annoying, it can get on people's nerves, and that leads to violence in our prisons. We have the most violent prisons in the nation right now. Alabama does. We also have a problem with suicides in our prison. We also have a problem with, sexual assaults and physical assaults. And it's not incarcerated people violating incarcerated people. Those numbers are not all of those situations. A lot of the numbers are due to staff violating incarcerated people. So it's not just incarcerated people, being violent towards each other. The staff are also being violent to the incarcerated people. We have encountered facilities that lack security in just that lead to extremely dangerous circumstances. Facilities that don't have cameras, facilities that if they do have cameras, they're turned in a way that doesn't capture anything. Cells with no locks on them, which allows people to just run in and out of a cell. And that's not good for security. So we became aware of these facilities several years ago and have gone into various places and interviewed people about what they've seen and what is going on in the facilities in which they're in. Our goal is not money in those situations. Our goal is to make the conditions safe and livable for the people who are in those facilities. So we demand, greater security, to fix the locks on the cells, to put cameras in places where they actually capture things, for incarcerated people to be able to report what happens to them and not be laughed at and to be taken seriously. So we're not seeking money, we're seeking change in those facilities. It's very tough, but we continue to do that work. If you search after this on Google, you can find where the Department of Justice produced 2 reports, basically finding Alabama facilities as unconstitutional when it comes to conditions. That's mental health and the facilities themselves and the treatment of incarcerated folks in those facilities. They've issued 2 reports about that. The other area in which we have gone into is assisting people who were sentenced to die in prison as children. Essentially what that is that our country was sentencing children below the age of 18 to life without parole sentences. Our language in choosing to say to die in prison is purposeful because we wanted to convey what it means to serve a life without parole sentence. And here in Alabama, a life without parole sentence is your natural life. So if you are sentenced at 13 or 14 years old to a life without parole sentence, that means that you will die in prison. You will never get the chance to come up for a parole review before a parole board. Essentially, you have been deemed to be a person who cannot be reformed. And we and several other organizations and lawyers want to fight back against that because it's not true. It's not scientifically true, and it's not true by just what we observe in common sense. In the early 2000s, there began a push for our courts and legal system to begin treating children as children. And we still believe that children are children, and that treating them and punishing them as adults is unconstitutional and should be stopped. So beginning in 2005, the United States Supreme Court issued a decision titled Roper v. Simmons, which made it unconstitutional to execute children below the age of 18. That was 2005. And in that case, the lawyers argued that children are different. Their brains are still developing up until the age of 25. Children don't pick who their parents are. They don't pick how their parents treat them. They don't pick any mental disorders. They don't pick any cognitive disorders. They don't pick any of those things. They don't have a choice in those things, and they don't have a choice in whether those things are treated. They also, a lot of times, end up buckling under peer pressure and end up hanging out with people who are a lot older than they are. That could be older teenagers or adults. And what we were seeing is that a lot of the kids who were 13 and 14 and 15 years old were being the most harshly punished out of their friend groups. So you may have a person who's sentenced to life without parole who is 13 years old, and they were caught up in a group of people who were 17, 18, or 20, 21. And the older people would not be, either be found not guilty or, make a deal with law enforcement to point the finger at the younger person. And the youngest person gets the harshest sentence, which is life without parole or a sentence to die in prison. And what we wanted to show the court system is that, not only should it be unconstitutional to execute someone under the age of 18, it should be unconstitutional to sentence children to such long prison sentences that they essentially die in prison. That's what we were being told once Roper v. Simmons came out, and the people who were on death row were moved to life without parole sentences. They were telling us we're still going to die. We're still not being given the chance to show that we were kids then and that we have grown and realized, what we did or what we were accused of. And we're still not going to get the chance to live outside and be adults. So building off of Roper v. Simmons, we, EJI, became involved in pushing the courts to abolish death in prison sentences for people under the age of 18. And the first of those cases was Graham v. Florida, which made it unconstitutional to sentence a child to life without parole for a non-homicide offense. We have worked with one of our former clients, Ian Manuel, is a beneficiary of Graham. He was 13 years old when he was sentenced to prison for a robbery, sentenced to die in prison for a robbery. His victim did not die. She was shot in the face, but she didn't die. And she was one of his biggest advocates throughout his time in prison. But we were able to secure Ian's release after he spent 27 years in prison, from the age of 13 to about the age of 40. And as a result of working with clients like Ian, we established a small reentry program called the PREP program that serves our clients that we have helped get released and helps them to acclimate to the world outside of prison. So we teach them how to drive, we teach them how to cook, we teach them how to order from a menu, things that they were not able to learn how to do because they went to prison at such a young age. And the rules of prison are very different. So we wanted them to learn how to acclimate to the world outside. The next case in that line of cases was Miller v. Montgomery and its companion case, Jackson v. Hobbs, which involved two young men who were sentenced to life without parole in cases that involved homicide offenses. We pushed the court there to recognize that children are children. Even if someone dies as a result of a crime, there is still a child involved. A child still committed that crime, a child whose brain is not going to be done developing until age 25. And that children are more likely to be reformed. They have a chance to and an opportunity to recognize their mistakes and grow into adults who recognize that what they did was wrong. So the United States Supreme Court agreed with our arguments and issued the Miller v. Montgomery, Jackson v. Hobbs decision. So at this time in the United States, it is unlawful to sentence a child to die in prison for a non-homicide offense and for a offense with a mandatory life without parole sentence. So you can still sentence someone to life without parole under the age of 18, but you have to be able to review their home life and their school records and their medical records. You can't just sentence them off of life without parole alone without giving them a extensive hearing where experts come and testify about how their life was. So we hope someday that life without parole will be abolished for people under the 18 overall, and without the caveat of it being a mandatory sentence. So that is the legal projects that we work through. And even through those projects, we were able to see the effect of race and poverty. Most of the children that are sentenced to life without parole, a large disproportionate number of them are Black children and Latinx children and children who are not white. And we could see from the school to prison pipeline how it played into children being funneled into these death in prison sentences. Studies and statistics show that Black children, children who are not white, are more likely to be suspended for crimes that more likely to be suspended for behavior at school that white children are not. Young Black girls are assumed to be older than they are. Young Black kids are assumed to be presumed guilty for things that white kids are not. So there are a lot of child behavioral assumptions and school behavior assumptions that have been, that are in place in a lot of Black and brown children's lives that lead them into a life where incarceration is normalized. And I'm very sorry, my dogs are really going crazy right now. I'm trying to talk louder than they're barking. So what we were seeing is that race and poverty were really big factors in how people's life trajectory was going and their trajectory along the criminal legal system. So about 10 years ago, we realized that we were it would be best for us to start thinking about how can we educate people on race and poverty who are not judges and who are not prosecutors. How can we get people to see how those two things can play such a big part in people's lives and in how they get treated in the criminal justice system? So we began doing racial justice work, and our racial justice work is just as important and just as big as our criminal defense work, and they're meant to inform each other. We believe that it's not possible really to have a in-depth and substantive conversation about the criminal legal system if you're not talking about race and poverty, and especially if you're not here in the United States, if you're not talking about our country's failure to confront our nation's history of racial injustice. So we began speaking of our country's history of racial injustice in terms of 4 eras. We start out with, before our first era, recognizing that this country, from the first time that settlers arrived here or explorers arrived here, that our country is the result of the genocide of Native Americans. And then, that narrative of, Native Americans not being human, them being less than white people, becomes a narrative that begins being used against Black people when they are kidnapped and brought here from the African coast to the United States. That narrative of racial inferiority is applied to Black people as well. And that narrative is used to justify chattel slavery, which we consider the first era in this nation's history of racial injustice against African Americans. That narrative of Black people are not, they're subhuman, they're not, smart, they are violent, they are guilty of whatever we accuse them of, that is, crystallized in our Constitution through the 3/5 compromise, where Black people were not counted as part of the population as a whole person, but as 3/5 of a person. That narrative is right there, that Black people are not wholly human. They are property, and they are people who should be subjugated for their entire existence amongst populations of white people. When the Civil War ends in 1865, slavery does not end. It just continues to evolve and pop up throughout the next couple of eras as a different beast, but as slavery, but in a different form, in a different face. So the Civil War ends in 1865, and the 13th Amendment is passed, which abolishes slavery, but abolishes slavery for everyone except those who are incarcerated for a crime. So there's a loophole that allows people to exploit the 13th Amendment. And white supremacists do that. They engage in a system called convict leasing, which allows them to incarcerate Black people more so than anyone else, and for all types of things that were not really crimes but became criminalized in order to incarcerate them, and lease them out to corporations and farmers and businesses and not pay them. So you have that system operating alongside other types of schemes and systems meant to control and subjugate Black people. You have an increasing number of racial terrorist acts lynching during this time after the Civil War through Reconstruction from 1866 to 1877. You see Jim Crow and segregation start to begin, where Black people are separated from white people in facilities. You have lynchings that begin to rise up in numbers. Black people are killed in the thousands and hundreds of thousands, more than likely. EJI documented over 4,400 lynchings between 1877 and 1950. This was a extremely terrible time as for racial violence. It was, there was a complete backlash against the civil rights that Black people were demanding that be recognized. And white supremacists were taking out their anger and resentment in extremely violent ways. They were shooting whole families, shooting people in front of courthouses. And by people, I mean African Americans. They were accusing Black people of violating white women. And that could be, in a small way, such as they stared at a white woman too long, or they whistled at a white woman, or they accidentally bumped into a white woman. It was always believed that the act was way more than it actually was. And actually about 25% of lynchings during this time period, about 25% were accusations of sexual assault. And even though a Black person may be arrested, they were often, arrested, placed in jail, and white mobs would show up at these jails and at these, and fight their way into the jails and drag the Black person out and shoot them, hang them, castrate them. They would tell, tens of thousands of people might show up to a lynching. They might wear their best Sunday clothes. They might bring food and picnic and have a picnic around the body. Sometimes they would take parts of the body once the lynching was over as souvenirs. They would take locks of hair. A big business during this time was the lynching postcard. Someone would come and take pictures, and the families would get copies of these pictures as postcards and send them off to other family members across the country. This was such a popular thing to do that eventually the postcard makers would, the Postal Service said, this is actually kind of not good. It's kind of gruesome. But families would then start putting the postcards in envelopes to hide the really horrific picture, in which sometimes the families would be posed around the body that was hanging or that had been burned, or where the lynching had taken place. This racial terrorism caused a exodus from the South. About 6 million Black people left the South as a result of this racial terrorism and went west, north, and Midwest. And the Great Migration is often, which is what it's called, is often viewed as a jobs opportunity, but it was more so a fleeing from racial terrorism. People were terrified to remain in their communities because they had seen someone lynched or heard that someone was going to be lynched, or they themselves might have been threatened with lynching, and they gathered up their whole families and left. As lynchings began to subside in the 40s and 50s, you still had Jim Crow, you still had segregation, but Black people, again, were still fighting to use the same facilities and have integrated schools, because separate but equal was not really equal. The facilities that Black people had to use, whether it be schools or bathrooms or whatever, were abysmal compared to the facilities that white people had access to. So starting in the 50s, you had a greater push to abolish this separate but equal scheme that was going on. So we start moving into the era of what we call resistance to integration or segregation. And this is where you have people such as Fannie Lou Hamer and Rosa Parks and Martin Luther King and Ella Baker, who begin the civil rights movement and doing sit-ins and forming organizations that are fighting to get Black people's civil rights recognized. But what you also have is another extremely violent era. The civil rights movement is often taught as a happy time, and it was not a happy time. It was not a 3-day carnival where Rosa Parks sat on the bus and said no, and Martin Luther King gave his "I Have a Dream" speech, and then the Civil Rights Act and the Voting Rights Act were passed. It was a very violent time. Martin Luther King's home was bombed. He was eventually assassinated in 1968. He was arrested dozens of times. He was, hit and beaten. John Lewis, crossing the Edmund Pettus Bridge, said that he was, there was a time where he thought he was going to die when he, would do voting rights marches. Rosa Parks was arrested. She was not just simply excused when she sat on the bus. She was pulled off the bus and arrested. So it's a time that was very violent, and people were beat and homes were bombed, and people in government, George Wallace, Talmadge, you had a lot of government actors who were blatantly white supremacist and blatantly racist. This is where you get George Wallace saying segregation then, segregation now, segregation forever. So this is that time period where you get a lot of just blatant violence and racism. Even though this period of time was successful in getting legislation passed, that feeling of success didn't last for long. It immediately moves into what we call the mass incarceration era, which is the era that we're in now. Starting with after Martin Luther King's assassination, you have this rhetoric that arises with politicians where they're, essentially, again, looking for a way to subjugate Black people through politics and through racism. But this time it's a little bit less obvious. It's through coded language, and it's through imprisonment and disenfranchisement. So this is where in the 70s you start to see the rise in the prison population. You start to see politicians talking about a war on drugs and a war on being tough on crime. And leading into the 80s, you see a closing of mental health institutions and the rise in unemployment, and subsequently, paralleling that, an increase in the use of a new drug that has hit the streets, which is crack. You then have the implementation of sentencing disparity between crack and cocaine. Because of the cost of cocaine, it is less likely to be used by people who are poor, and people who are self-medicating with drugs are more likely at this time to use crack cocaine. However, the sentencing scheme calls for a harsher sentence for crack cocaine than it does cocaine. So you see more Black people and more poor people being funneled into our prison system through the sentencing disparity and this war on drugs, and mental health and addiction being viewed as a criminal thing and not as a healthcare problem as opioids are viewed today. So that leads to the population of the prison exploding, as I explained earlier, from the hundreds of thousands to 2.2 million people, and the disproportionate number of those people being Black people. And that is not because Black people use more drugs. It is not because Black people are inherently more violent. We are impacted by disproportionate law enforcement rules and disproportionate policing. So that is what leads us to where we are today. At EJI, we believe that the sooner we confront this history and realize that it is all tied together and has led to what we are experiencing today, we believe that the better we will be as a nation. We can move forward with healing, but people have to realize that, you know, even though slavery seems long ago, it was not long ago. I saw a story the other day about a 102-year-old Black woman voting, and her grandmother was an enslaved person. You have people today who are alive whose parents were sharecroppers. You have people who are alive today who were sharecroppers. People who are alive today who lived through Jim Crow, who lived through segregated schools. These times were not long ago, and all of these eras are connected, and they go through all parts of our society, from education to incarceration to healthcare, through hiring and all of our institutions. And we put out reports. We have built several sites here in Montgomery to educate people on our nation's history and to commemorate the people who were victims of racial terrorism. So, you know, if you ever get a chance to come to Montgomery, we have our Legacy Museum, which lays out in visual the 4 eras that I just described. We have our Peace and Justice Memorial, which commemorates the 4,400 people who were lynched from 1877 to 1950. We have smaller memorials dedicated to those who were lynched before 1877 and those lynched after 1950. And we have our pavilion, Legacy Pavilion, which has a transatlantic slave trade exhibit that will be here until November 30th. So we strive to educate people so that when you go in, when you interact with someone who doesn't look like you, when you interact with someone who doesn't have the same religion as you, when you go to a courtroom and serve as a juror, when you go to the polls and you vote, that you will realize and recognize and be aware of how our history has not been confronted, how it needs to be confronted, and how that will help us move forward as a nation. Dr. Carmichael, I'm going to turn it back over to you for question and answer.
Thank you, Attorney Ashley Adams, for that comprehensive overview of the commitment and work of the Equal Justice Initiative. We have some questions from those in our audience, so I'll go through them. The first is from Lisa. Her question is, does EJI need volunteers? And if so, could someone work remotely during this time?
We are not currently in need of volunteers for, I guess, our legal work. We do often need volunteers for our soil collection, which I forgot to mention in my overall presentation. We have a community remembrance project, and part of that project is our soil collections. And what the soil collection is it is a mason jar, where we collect the soil from a place where someone was lynched. And we put their name on the outside and the date they were lynched. And we place that in one of our sites. We have an exhibit in our museum. We also have some in our main office on Commerce Street. But if you are interested in doing a soil collection, we often take volunteers to do those. So you can contact us, go to our website, and through our contact us, you can write in there and send us an email and let us know that you would like to do a soil collection. We also, I guess I forgot, we also are actually in need of legal representation at times. When I talked earlier about that post-conviction stage, we are not able to represent everyone on Alabama's death row. So we are often looking for attorneys, people who can assist us, who can represent someone on Alabama's death row, who can assist with, represent them in their post-conviction stage. So if you're an attorney and you would like to take on a capital case that's in the post-conviction stage, please contact us. We may be able to put you with someone on that. I think that's about it right now for our volunteer opportunities.
Thank you. Aaron has asked a question. After the national participation in the protests that started after George Floyd's death, have you seen any indication that the justice system in Alabama is likely to change?
We haven't seen any immediate changes. There are currently plans to build 3 new prisons, which is not good. What we've seen happens when new prisons are built is that they eventually become overcrowded. The state is saying that they are building these new prisons to correct overcrowding, but what we've seen is that those prisons eventually become overcrowded too. So we are, that is a little nerve-wracking to see that happening. But we haven't seen any immediate changes here. We hope that, of course, with any new changes over the next Tuesday, that maybe some new people, some new thinkers will come in, and we will be able to, that some changes will start happening. But we haven't seen any immediate changes just yet in Alabama.
Okay, thank you. Yvette wants to know, or Margie wants to know, what's the best way to donate to EJI?
We have on our website, www.eji.org. There is a place where you can donate. I think it says donate, or it might be under like help us or how to help. But there are links on our website where you can donate through there. And if you can mail us, our address is on there if you want to mail it and don't want to do it through the computer. But there are links and information on how to donate on our website.
Okay. You mentioned when EJI started that Alabama's death row rate was about 25%.
Yes, we accounted for 25% of the executions. Yes.
Thank you. Has that changed since EJI has been doing their work?
Yes, it has changed. We are not we don't take up a chunk of executions like that anymore. We still are having executions. We had a couple that were scheduled last year. We had a couple that were scheduled earlier this year. But the most of the executions come out of Texas. And that's been kind of the trend for a couple of years now, but we don't make up 25% anymore. So we have been able to bring that down.
Okay. How did the Montgomery community receive EJI and receive Stephen when he started this work in that area?
They were not very receptive. In the movie Just Mercy, they kind of give I think in the book too, they kind of give an overview of some of the obstacles he faced. He had it was hard to get a building to work out of because people did not want to lend a building to someone who was defending people on death row. Mm-hmm. There were a lot of the judges and prosecutors were not very receptive to Brian because he was Black. Some of the prison guards were not receptive at all because, he's a Black man and he's representing people on death row. And we still have, issues with, going into really small towns and small courthouses and things like that. But yeah, there were some issues in those earlier years.
Thank you.
Montgomery loves, we've been here for 30 years. We've always been in Montgomery. Okay. So the community here has shown great appreciation for our presence. We love the fact that we're here and able to be in this community. We think it's the best place for us to be because of the history of civil rights here in Montgomery. So it's a great place for us to be.
Thank you. You spoke a lot about sentencing, with the child on child and things like that. Does EJI look at the type of charges that are brought. So when you talked about the prosecutors deciding on the actual charges that are brought, and does race make a difference in what the accuser is actually charged with? Have you found anything in there?
Yes, yes. What you're charged with does make a difference. What you are and what your race is when you're charged, I mean, can make a difference. What we've seen here, you know, because economic injustice, poverty plays a part in it too. So if you are a person who has money, that's probably going to, you know, you're more than likely going to be able to hire experts and hire a trial lawyer who has a lot of resources. So you're more than likely going to have representation at the trial level that where you may not even get to a trial. It may be dropped down or pled to something totally different or something much less. But if you are poor or Black, you are going to be facing an uphill battle because you're going to be, if you're not facing an obstacle because you're poor, you're going to be facing an obstacle because you're Black. You're going to be in courtrooms where the judge is more than likely white, the prosecutor is more than likely white, your defense attorney is more than likely white, and your defense attorney may be racist. I mean, that's something that has definitely happened. In the case of Anthony Hinton, Mr. Hinton, who's a client that we were able to get off death row after 30 years, he spent 30 years on death row for a crime he didn't commit. His defense attorney, who was appointed to him, when Mr. Hinton told him that he didn't do the crime, his defense attorney responded, "Y'all are always saying that you didn't do something." So, you know, it's very possible to end up with a defense attorney who detests you simply because you're Black.
Wow. Thank you. We have another question that was presented. In addition to educating ourselves, what practical steps can a white person take to support equal justice in our world?
Practical steps is continue to educate, read. I have these, I was trying to figure out how to get the books in here. I have these books here behind me. I always urge people to read, even though I, you know, do this work all the time. I still read and just, you know, kind of try to consume as much information as I can about our nation's history. A lot of what I've learned about history has just been here working at EJI, because there's a lot of stuff that I wasn't taught in school. And when you're, you know, taught in Southern schools, there's a lot of stuff that gets taught inaccurately, especially about the Civil War and about racism. So I think these are great books. Caste by Isabel Wilkerson is a great book. It talks about how she basically is using the analogy of the Indian caste system to argue that that Black people in America that race is a caste system here in the United States, and that Black people are on the very bottom, like the untouchables in India, and that white people are at the very top, and that all of our interactions and our lives are shaped by this caste system. Gideon's Promise is a book by Jonathan Rapping. It has a foreword, I believe, by Brian. Jonathan Rapping is a former public defender. He is the founder of an organization called Gideon's Promise that trains public defenders. And it's kind of a new way of training public defenders to be client-centered, which is to recognize that your clients are the best people to drive their case. But also just kind of teaching about what it means to be a public defender and how we're different from private bar attorneys. So it's also a very good book to read if you want to know more about public defense in this country. And then this one on the end here is The Sun Does Shine. It's by Mr. Anthony Ray Hinton, who I just talked about. This chronicles Mr. Hinton's 30 years on death row, how he was arrested, and how he was placed in prison and placed on death row for 30 years, and how EJI helped him get off death row. It also has a foreword by Brian in it. So continue to read, listen to Black people and people of color when they talk about racism. A lot of times people shut their ears to racism, you know, because they think that it means they're a bad person. Sometimes people do things that are racist or prejudiced, not as bad people, but because they just don't know, you know, out of ignorance. And, you know, you have to be able to open your mind to really think about what it is, the actions that you've done, and listen to people. Voting is another way to, you know, practice what you've learned. When you are listening to ads and listening to political speeches and, you know, reading about, you know, politicians and people running for office, you know, you can go through their bios and who they've been involved with and, you know, kind of sort out, like, is this someone that's going to be good for this office? Is this someone who's going to make the kind of changes that I want to see? So those are ways that you can utilize what you've learned and ways to continue learning.
Thank you. Yvette has a question. You mentioned the Department of Justice reports on prison reform. And wondering, do you anticipate those leading to any real change?
I do. It's just not happening as quickly as it should. The response that we got from the most recent report, which was released earlier this year, was the Attorney General saying, "Oh, I wasn't aware that this was a problem," which is just a ridiculous response. So that doesn't give me much hope that we will be, unless someone else comes in the office, that doesn't give me much hope that we will be making fast change on those. And the state also has to have the ability to feel some shame. And it doesn't appear that they feel shamed enough yet to make change. I think they thought that building the 3 prisons would be alleviating the problem or fixing the problem. And that's not going to alleviate the problem. It may alleviate for a little bit, but it's going to, it will be a problem again very quickly. But I do have hope. We do have hope that our work will lead to some change. It's just going a lot slower than we would like it to.
Okay, thank you. Richard asked a question. Are there any initiatives to get rid of bad judges? I feel that the judges should be able to stop some of these injustices.
Because judges are elected here and not appointed, it is really one of the only ways. It's not the only way, but it's just really hard to get rid of bad judges when they're elected. Because especially when they're elected in a state like Alabama, where conservatism is essentially down in the bones of a lot of people who vote here. So it is, their terms are 6 years. So, there are several judges being facing election in this election on Tuesday. They won't be up for re-election until 2026. So their terms are not lifetime appointments, thankfully, but they are, really one of the best ways to get them out is to educate people on their rulings and how they, things that they've said, and to, encourage voters to be more cognizant of the judge's politics and vote them out of office or don't vote them in again. We also have this issue where a lot of judges run unopposed. The judges that were on the ballot for Tuesday, there were about 6 seats, and they were all unopposed. So a lot of times judges here don't have to really do anything to keep their seats or to get into a seat. They essentially know that they could get to a seat and not really have to do anything. But it's a good old boy system. They're going to protect each other, and what it's going to take is just kind of like a massive, kind of like election where there's opposition and they really have to work for their seat. So.
Thank you very much, Attorney Ashley Adams. And thank you all for participating tonight. And thanks to the Miami University Alumni Association for hosting our conversation. You can see all of our online events on our website. And most importantly, again, thanks to Attorney Ashley Adams and the Equal Justice Initiative for their time tonight and their amazing work. Have a great evening.
Thank you all.